So we will be facing facts and confronting fiction. Dun, dun. All right. I'm not sure quite why this is off to the side there, but we'll work through it. It won't be a big deal. Charter schools as public schools. Because of this series and of all of your work, you know that charter schools are in fact public schools. There's a lot of misunderstanding about that in the media, in public perception, in political circles. Turns out there's also a fair amount of confusion about it in the context of the law. And that's a much more difficult thing to remediate, in my opinion, than working through it in some of the other realms, whether political or in public relations discussions. So the myth that charter schools are public entities in the eyes of the law. The key word there, key phrase, any guesses? Public entities, right? So public schools mean one thing under the law. Public entities means a different thing. And it's not a very easy definition. In fact, we wanted to dig into what the definition of public entity was. And it's got a variety of terms: political subdivision, agency, instrumentality of the state. We picked 4 states, tried to understand the history of that term, and then understand its evolution to apply to charter schools. It was 164 pages just to dissect 4 states, their statutes' use of that term. So this confusion about what is a public entity is something that exists across the board, across all states, in a variety of ways. Charter schools are implicated because of what you'll see here, right? First, we are tuition-free public schools. It's a given. Everyone understands that. Everyone in this room understands that, at least. Charter schools are funded by taxpayers. Again, another indicia of publicness, public schools. Charters are embraced as public schools by state laws, state constitutions, and federal statutes, clearly defined and interpreted as public schools performing a government function. There have been certain challenges under state constitutions about charter schools' publicness. Those have all been defeated. Charter schools are soundly accepted as public schools. Nevertheless, charter schools are not always treated as public entities under the law. So there's a very clear disconnect that doesn't apply to traditional district schools, because traditional district schools all live inside the local education agency, the LEA of the district. The district is clearly a public entity in every definition across all states. So if we had done that same research across those 4 states with respect to public entities and public schools, it would have been a 1-page document. The answer is always yes, right? So we had a 164-page document because it's like, we don't know. But it's never the case that that confusion reigns when you're talking about traditional district schools as public entities. They clearly are. So the first question, well, why is that the case, right? What drives that distinction? From a legal point of view, it comes down to the fact that charter schools are public schools, like we discussed earlier, understood that way, perform that function, funded that way. But in terms of the relationship between the employees and the management, right, the charter operator holds the contract and employs teachers and staff privately. So there's a private relationship, a private employment relationship that takes the entity or the identity of public charter schools outside the realm of public entity-ness. And so why does that matter? Well, there are lots of implications under the law. So not necessarily from a public policy point of view in terms of understanding charter schools as public schools, not from a parent point of view in terms of enrolling students, but in terms of the laws that apply to charter schools. So examples of that. Labor laws. If you are a public entity, if you are a political subdivision, then your state labor law applies. If you are not, then federal labor law applies. You are under the jurisdiction of the National Labor Relations Act. So there's a tension there. And certain charter schools are compelled to join collective bargaining agreements, and that's sort of a non-issue Many charter schools are not only about 10% of charter schools are unionized. That's not by law, that's just the extent to which employees have chosen to create unions. There are some states which require charter schools to participate in their district's collective bargaining agreement, but again, that doesn't happen very often. So for the most part, you've got charter operators deciding if they want to act as public or private employers, and that's just a choice that traditional district schools don't have. And deriving from that choice are a ton of consequences, one of which is labor. Another one would be the IRS. Certainly tax-exempt status is granted to all charter schools. They're all nonprofits, even ones that contract with for-profit providers. The contract is given to a nonprofit entity. So the board of directors is for a nonprofit entity that has tax-exempt status under the IRS. But the analysis sort of doesn't stop there. Just recently, some of the work that I've been engaged in discusses the implications of, I'm going to apologize in advance because there are a lot of words that are about to come out of my mouth. So governmental plan exemptions for state pension plans. So state plans can be treated as government plans and given certain exemptions from ERISA. Okay, people are nodding, that makes me feel better. Charter schools have so far been allowed to participate in state plans without jeopardizing the governmental plan exemption of those state plans because they've been deemed to be agencies or instrumentalities of the state for purposes of the IRS code, right? That's helpful because, as Todd, who will be here in a few weeks, will mention, according to the model law, one of the main components is access to state plans, right? For labor purposes, a lot of charter schools want to be able to offer state pension benefits to their teachers. And so far, the IRS has said, fine, we'd love to have you. State plans are happy with it, everybody's happy. The IRS in November put out advanced notice of proposed rulemaking to narrow the definition of governmental plans, not because they were after charters, they were after some other entities, but when they start to narrow the plan, it impacts the way that charters could be interpreted. So what went from very clear understanding through private letter rulings of charters as agencies or instrumentalities of the state, now that bright line rule is being condensed to one of a multi-factor test, so there's now not just one consideration, there's 13, and charters really only satisfy a handful, which makes them substantially less likely to be treated as agencies or instrumentalities of the state for purposes of the IRS and state pension plans in particular. And where's the there there? The there there means that charter school teachers and employees are likely to know, or potentially faced with risking their pension benefits, which is a big issue. We estimate about 95,000 charter school employees, which is 93% of the workforce in charter schools, would be impacted. They'd either lose benefits altogether if they haven't vested, or they would certainly lose expected retirement wealth because they would be kicked out of the system somewhere along their career and not be given what they've been promised. From a lawyer point of view, there's a lot of legal challenges to be made should that ever come to pass, but for our purposes, it's just important to realize that when charter schools are not understood and treated as public entities under the law, there are all these ripple effects that really do impact the day-to-day operations of the schools. I never expected that my work doing charter school law would be about this, but a lot these days, most of my work is spent trying to figure out what it means for charter schools to be sort of quasi-public entities. And the quasi-ness, again, comes not from the mandate to serve all students, the mandate to be tuition-free, the mandate to be public schools. That always holds. The quasi-publicness really emanates from the private contractual relationship between the school and its employees, and then kind of all the repercussions from there. An example that's very lawyerly, and you have to forgive me, is one that about to sue or not to sue. So we know that school districts are often immune from certain types of suits. Tort immunity, certain types of civil rights immunities, 1983 immunities. For the lawyer, if you were lawyers, you'd be very excited and we'd talk all about that, but luckily we don't have to. It's very dense and I'm not an expert, so I'm relieved. But one thing we do know, and you're probably very familiar with the school districts often cannot be sued. The question about charter schools is whether or not they are public entities in the same capacity. I see you're not, it's true, school districts can be sued, but they often enjoy arguments about types of immunity that they might be afforded. Charter schools may not always be able to make those arguments about immunity in the same way. And so oftentimes charter schools are trying to say, listen, we are political subdivisions for this purpose of immunity. Let us be political subdivisions. We don't want a disgruntled parent or employee to be able to sue us in the same way that they can sue a private entity. They should be able to sue us the same way they could sue a school district, but not more than that. And courts are sort of all over the place with that. It sort of depends on what the issue is. At the same time, charter schools sometimes say they want to be able to sue the state. So in that instance, according to law, if you are a part of the state, if you are a political subdivision, you can't sue yourself. So if you're deemed a political subdivision, you can't sue the state. You don't have districts suing the state often. I mean, certainly you do see it in certain contexts. Charter schools often want to be able to sue the state because the state's not funding them correctly, not supporting special ed services, not being good authorizers. You can think of a number of reasons when it would be important for a charter school to be able to flex and sue the state, but in that instance, that school would want to not be deemed a political subdivision. So it just sort of sets, it sets up this question about how will the law evolve over time to help people, charter schools, have a more refined and transparent legal identity. I mean, it's clear what their mandate is, but the law hasn't quite caught up to help charter schools have a clear legal identity with respect to public entity-ness. Any questions? We just relieved that part is over. Okay. Myth number 2, charter schools and civil rights. The myth, charter schools can be measured by the same civil rights metrics as school districts. So I tried to word that carefully. I definitely welcome dialogue about it, but the key words for me there are measured by, right? The same civil rights metrics as school districts. So what do we know is true? Charter schools are bound by the same civil rights laws. No one's debating that. Absolutely the same laws apply. And charter schools are expected to serve, the word missing here is all students, right? So again, there's no debate about that. So then what is the debate about? Well, because charter schools are not assigned students, right? Well, there's a semicolon, you can't see it. Charter schools are not assigned students. Therefore, existing legal constructions have not yet adapted to schools of choice. So what does that mean? Right, traditional district schools are assigned students by the district. Most of civil rights law, as it is applied to school districts, is based on that construct. Bad actors are inferred from the way in which districts assign students. Schools of choice turn that all on its head. That doesn't mean they're not bad actors. It just means that the law as it's been conceived and applied so far needs to be adapted. In schools of choice, parents are picking the schools they want to go to. Right? That doesn't mean there can't ever be discrimination. The discrimination or the intent, effective discrimination could still exist, but you would have to come up with another way of understanding that, measuring that, evaluating that, and applying legal standards to that. And the law hasn't gotten there yet. I see some, any questions? Not yet. Yes.
And maybe I'm jumping ahead, but what thoughts might you have on what would those measures be? I
Yep.
know there is research out there looking at the impact of lotteries on racial segregation and these sorts of things.
Yep.
If not that, what would be? How would you measure it?
Well,
What thoughts do you have?
I think it's an open question, and that's exactly where we're going with the example. We might as well just get there. So just to give some context, and maybe everybody's sort of on the same page with you, but just in case, let's just take special education enrollment, right? That's clearly something that charter schools are dinged for not serving special ed students. And the idea is, or the accusation is that charter schools don't enroll special education students, right? That's one. They don't serve special ed students. That's another. They don't do inclusion well. There's all sorts of ways that charter schools are accused of not serving special needs students. But let's go with the first one in terms of access. The way in which traditional school districts are judged for serving or not serving special needs students typically tends to be percentage of enrollment. And then those things are compared across districts, schools, LEAs, SEAs. Charter schools sometimes are their own LEAs, and so that same construct applies. Sometimes they're not their own LEAs, and then it's slightly more attenuated. So part of like understanding the access question, I think, begins with understanding the charter school's LEA status, right? So that's just it's a legal, like that's the first threshold question. But let's just assume a charter school is an LEA, right? Then the expectation would be that it serves every student that comes to it, and you could argue that a charter school should have the same or approximate the same percentage of special ed enrollment as the district. Well, part of the tension there is that a district will often, not always, but often assign certain schools to serve certain types of disabilities. And so a student with an autistic need goes to one school, a student with a different type of need goes to a different school. Charter schools don't have that luxury, right? And a school district can do that type of assigning or clustering because it's one LEA. And as long as the LEA serves all the students that come to it, the how is actually, there's a lot of deference about how that is done. Charter schools that exist as a single entity LEA operate at a much smaller scale, but their legal obligation isn't any different. I'm not arguing it should be different, but in terms of the way in which charter schools are expected to operate, you know, they don't have the luxury of saying, well, you're this kind of student, we're going to have you go to that campus or go to a different, you have to stay here. And so I think part of what feeds the accusations about not serving special needs students is that maybe charter schools are not always as good as they could be about taking every student and finding a place, not because their intent is bad, but because it's actually pretty hard to provide a full continuum of services to every student that comes to you, no matter what type of student, what kind of needs that student has. And districts can't actually do that on every campus. Districts aren't expected to, and districts don't. But charter schools are expected to, and many try to. Some don't do it as well as others. But to your question about what kinds of tests make sense, it's because the problem is defined in those terms, that this charter school is not serving 15% special needs students, and that's the district's average. What's the problem? Well, authorizers and SEAs and courts and advocates look at that disparity in numbers, and they're looking at just enrollment data. And they're saying, someone's falling down, you're only serving 8% special needs kids, not 15%. There must be some sort of discrimination, either an intent or an effect, and you're a bad actor. Now, I wouldn't try to defend any school on those charges. I mean, you have to really dig much deeper. It's true that you could serve 8% and be discriminating. It's also true you could be serving 8% and not discriminating at all. So the question comes down to me, it's not output questions. When you're evaluating data, it's not how many kids do you have enrolled, it's are you doing child find, are you making sure there's access, how are you making sure there's access, do you have strong community partners? It's substantially more organic and a lot harder to evaluate and develop metrics around, but I think it can be done. Once you create ways in which you evaluate access, then I think you have to go deeper and talk about attrition. Attrition is data that I think is probably a fair data point. So if a charter school is actually demonstrating it has access, there are ways in which it's attracting students, that it's not counseling out. So you've got some sort of a needs blind enrollment application, so that if I'm a special needs parent and I go to your school, you don't ask me if I have a special needs student. I know that you serve special needs students because that's what your child find work has told me. I've come to you, I apply, you don't know what my kid needs, you take the kid, and then you go through a process of collecting the IEPs and what have you. And as long as a school can demonstrate that sort of openness in its access as marketing, recruitment, as well as in its enrollment, then I think and there's a lot of issues about how you collect that data, how you make sure that's not happening. To me, it sounds like you'd have to do a lot of what housing advocates do in terms of testers, and you actually do see advocacy groups around the country pretending to be parents of special needs kids, going up there and going to a charter school and finding what happens or what doesn't happen. I'm not suggesting it's the most efficient way to oversee things, but you do start to see some of that happening. Beyond that, if you're looking for a way that an SEA could evaluate, or an authorizer could evaluate the way in which a charter school is or is not serving special needs students, I would look at attrition. I would look at discipline data. I think that there are ways in which you can identify outliers in terms of the way that special needs students are served, but it's not going to be enrollment data. It's not going to be the same kind of data that traditional districts have, because at the end of the day, these are schools of choice. You can't assign, a district cannot assign a special needs student to a charter school. A district or an authorizer cannot require an incoming student to go to a particular charter school, and it's not because it burdens the charter school. The way that special education lawyers have explained it to me is that you actually violate the special education student's civil rights by forcing that student to go to a particular school to even out numbers. If that student doesn't want to go to that school, that student shouldn't be forced to go to a school when a regular ed student would not be forced to go to that school. You have to treat the special ed student as well as a general ed student exactly the same. So that's why some of the enrollment data doesn't actually work to support accusations of discrimination in intent or in effect the same way that it has been used in traditional districts. You have to come up with something more rigorous. Any other questions? Did that answer? It was a long answer. Okay. Any other questions? Another example of this is in deseg orders and the ways in which, and we can go into detail on this if you'd like. So there are a lot of charters. Did I do something? Okay, I saw a screen. There are a lot of charter schools that are opening up in jurisdictions where there are existing desegregation orders. Either they're voluntary deseg orders under Title VI and with OCR, or they are court mandated with DOJ and they are ongoing. They haven't been closed out. These districts have not achieved unitary status, and they don't sit in good eyes, or they're treated with a lot of suspicion by the courts. Like, what is taking you guys so long? Clearly these districts are not trying that hard, and the courts are all over the place with the enforcement. What's been interesting is when charter schools start to be authorized by districts that are under deseg order, right? Because that can be interpreted in a number of ways. It could be interpreted as, here is a district that operates racially identifiable schools and has for 40 years and is doing absolutely nothing to change it. The courts have gotten tired of trying to figure out how to enforce it. Case law has evolved, changed, moved backwards, regressed, and now the courts can't actually enforce it. But here comes a charter applicant. The charter applicant wants to open up, and the district says, sure. Is the district a good actor or a bad actor? Is a charter school going to have a good impact on the community or a bad impact on the community with respect to the deseg order? The way that this has been handled so far is that either OCR or the court, the enforcement entity, is involved in the approval of that charter applicant. It's happening all around the country, mostly in the Southeast, but you see this type of oversight by either the courts or OCR. The process is the charter school is approved either by the district, by some other authorizer, it can even be a statewide authorizer. But the question is, where is there going to be impact? If the school opens up and draws certain students, how will that impact the district's ability to comply with existing deseg orders? If you're going to bring in all these other students such that the remaining schools will be even more racially identifiable, the standard is that charter school cannot open because it will have a deleterious effect on the district's ability to comply with the existing deseg order. Right, so parent choice, none of that is considered. It's all about the structural ways in which the district will or will not be able to comply with the existing deseg. Authorizer approves the school has to go to the court or OCR. They go through this whole discussion about where the charter school is going to be located, how it's going to be recruiting and enrolling students, how will that recruitment be overseen, what targets, and by targets I mean quotas, will be applied to the school in order for the court or OCR to judge whether or not that school is negatively or positively impacting the district's ability to comply with the existing deseg order. It's a very delicate dance, and it's substantially more complicated than I think critics explain. And it's not like just theory. This is what happens regularly. I've actually assisted a number of schools in Louisiana that tried to open up this way. There's ongoing, 2 schools in South Carolina have been going through this. And those are just the ones I know about because I've actually helped them. I'm sure it goes on well beyond that. There's just concern that a bad acting district, right, that has never actually made substantial progress to satisfy green factors or any other factors should be given the discretion to open up schools of choice, because schools of choice could actually just be a euphemism for white flight schools, and so that's what triggers all of this additional oversight. Unfortunately, it also, like, that suspicion is warranted. I'm not second guessing that. At the same time, the deseg orders are very cumbersome, and they are trying to solve a problem that sometimes charter schools are also trying to solve, but because a deseg order is written a particular way and enforced in a particular way, there's friction there and tension that if we were all able to like agree that we're trying to do the same thing, somehow the deseg order would seem antiquated. Not that it shouldn't apply to the district even still, but maybe there's a way for charter schools to be able to have some sort of independent identity in the way in which they draw forward or extend the deseg order. So a specific example. A lot of these deseg orders will say things like a school district cannot approve a transfer of a student who is of color and trying to go to another school if that will further decrease the student of color population at a majority white school, right? So basically it limits the school district's ability to approve a minority transfer out of a majority school, right? And that's all about confining the school district's ability to condone white flight. The way it plays out with charter applicants is interesting because you'll have a charter applicant come to you, it's a community group, parents of all races, trying to say, we want a good charter in our school, school of choice, et cetera, a Montessori option. This is actually a real example. Montessori option doesn't exist. We know we'd have an integrated student body. Go through the whole oversight process with DOJ and the courts. At the end of the day, a big sticking point is that that charter applicant cannot, in its recruitment plan, right, say, I want to take students from Washington Elementary because according to DOJ, all the students of color in that school are off limits. You are not allowed to take any of those students. Doesn't matter if those parents want to choose your school, you are not allowed to recruit those students because that's a majority white school. The students of color help the district that are enrolled there, help the district look better in complying with its deseg plan. That school's off limits. So then you've got a charter operator that's looking to serve a particular community. It's an integrated community. It wants to build an integrated school, but it can't because it's not allowed to basically poach the students of color from the elementary school that's majority white. It really does seem to sort of turn the purpose of the deseg order on its head, and right now the courts are not kind of able to adjust. So it's an interesting example of how charter applicants in some instances are actually giving districts an opportunity to more substantially comply with existing deseg orders, but there's a little bit of cart and horse problem here. DOJ would have to agree that that's what the effect would be. DOJ and the courts would have to agree with that and would have to allow the school to open, would have to see it work well, and would have to see over time that the district as a whole aggregately serves a more integrated population than it was before, but you don't really get that very often. It just turns into a big battle. Yes?
In that scenario, where do parents' rights to school choice come into play? Does that seem
That's the question. And so there's not, and I think it's a delicate question because on the one hand, school choice advocates will say, well, that should be paramount, but it's not constitutionally protected, right? Like we certainly recognize all this jurisprudence that says, racial diversity is a compelling state interest, and there's a constitutional protection for that. And there just hasn't been a way for school choice to be weaved into that. So we've been working on ways to build policies that would recognize that schools of choice that further desegregate should be viewed one way, and ones that tend to not do that should be viewed another way. The charter movement has lots of interesting political bedfellows. There are some people who would hear that and would say absolutely not. We absolutely need to have absolutely no regulation about parent choice whatsoever. I think, so basically if you wanted a white flight school to be created, then, that's parents' choice. I think I think those are sort of fringe people in the movement. Most advocates confronting this question recognize that that's not what charter applicants want to do, so they don't even have to push that issue. But there's real concern about how do you balance the respect for parents' choice with a long-standing commitment to creating integrated opportunities. Other questions? Civil rights and fiscal equity, this is the last one. Myth, charter schools are entitled to funding equal to that received by their traditional district counterparts. So this one isn't quite as tricky. That's, the others, I had some, key trick words in there. This one is just straightforward. Charter schools are public schools, and charter schools are required to comply with the education clauses or clause of their state constitutions. So what does that mean, right? So every state constitution basically says you have to provide an adequate education of some sort, and there's all this case law that discusses what that is. Well, charter schools are public schools. Charter schools will have to comply with that burden as well. But charter schools on average receive 75% of what traditional school districts receive. And that's just based on the per pupil formula in each state. Many critics will say things like, oh, but charter schools actually get all these foundation dollars, they get startup grants, so their per pupil is actually substantially higher when you aggregate all of their additional funding, whether federal or foundational. That's true maybe for certain schools or certain networks over a certain period of time. But that's really not the point. The point legally is that these are public schools with the same burden as traditional district schools, and they should be funded in the same way. The same kids are going to them with the same needs. And these schools have performance contracts that they have to meet in a short period of time, and if they don't meet that, they're closed down. It's very disingenuous to say not only do you have to make gains to satisfy your performance contract in a 3 to 5 year window, you have to do it on sometimes 50 cents on the dollar as your counterpart down the street. So the way we get to 75%, there are a number of jurisdictions or charter schools that operate in states where they get 50% of what their traditional counterparts get. There are there are others that get closer to 90%. So it really is a wide range, and there's a great study put out in 2010 called the Ball State Study that really documents the per student disparity in each state. Sometimes it's just staggering. Yes, question?
Could you say a little bit about what counts in that? I mean, I don't know the national context, but I know the Maryland context pretty well, and the fight's a bit about what counts as funding.
Yeah.
And is it just dollars? Is it facilities costs? Is
Yep.
it, that's been the controversy, and so as it ends out, at least here in Baltimore, schools get significantly more by the district's estimate, but a lot of the schools will tell you they don't. So when you say 75% on average, what are you counting?
I think we would be counting the same thing that the schools here are counting, right? Which is probably not counting facilities costs. You're probably talking about not getting, again, it comes down to LEA status in some respect. Charters that are their own LEAs are supposed to receive dollars directly from the state. They should have more clear accounting metrics. I think at the end of the day, in reality, when I was working in New Orleans, most of those charters are their own LEAs. They get written really big checks. They can't tell you for what it all includes, meaning they've got your special ed funds in there, you've got your standard per pupil in there, you've got all sorts of other costs, food services, contractual costs, things that for their own purposes the state lumps together, writes one check versus creating checks that are more easy, create more transparency. So I think that's part of what is the problem. We don't have a lot of clear accounting. And that's when schools are their own LEAs. When schools are not their own LEAs and they are supposed to be dependent on the district for pass-through funds, that lack of clarity is compounded. So you ask a very good question, and one that I think leads to a lot of confusion. The question about facilities is one that's being litigated a lot, where you see that the per pupil might be similar, but charters get no facilities dollars, so actually they have to reallocate their per pupil to pay for facilities. That turns into a disparity in the per pupil, and so when it all shakes out, you're operating on 50 cents on the dollar instead of the 75 cents on the dollar that your statute requires. So there are statutes that will say charter schools should be funded at X percentage of their traditional counterpart. You ask, well, how is that fair? Well, it turns out, fiscal equity suits are not the easiest suits to win, no matter if you're a charter school or a district suing the state. And there hasn't been a lot of, there are some suits underway challenging the equity. Well, okay, let's go to the 3 theories of suit: equity, adequacy, and compliance. Compliance is your statute says you're entitled to 75%, 90% of your traditional district's allotment, and you're getting 50%, so there's non-compliance there. That's one theory of suit. The other is the equity theory of suit. It's just inequitable, the way that this is being funded. Urban schools, suburban schools, we all know that sort of that has come and gone in terms of a way in which to actually get dollars. So adequacy, we start to see a lot more adequacy suits where charter schools are challenging their education clauses. The wrinkle there is that in order to be a good plaintiff, honestly speaking, you have to be a pretty good school. You don't want to be a crappy school because you just don't hold up very well in court. The problem with the adequacy claims are you have to demonstrate that you are providing an inadequate education based on your dollars. So it's very hard to prove. You can't demonstrate harm. We've had plaintiffs come to us and say, we want to file suit. Great, we're a high-performing charter school. We operate on 50 cents on the dollar. We're knocking it out of the park. And you're like, God, that is fantastic. There is no harm to your kids. Nothing to remedy. They're like, wait, it's not fair. If we had 100%, if we got exactly what our district counterparts got, we'd do so much better. You're not entitled to better. You're entitled to just as good. And you're not doing just as good. You're doing better than your traditional counterparts on half as much. So adequacy suits are tricky, complicated. Right now we have an equity suit, sorry to be jumping around, going through Arizona. And they just had the district file papers challenging charter school students as public school students. That when you start to, find pieces of different theories that work for you, you find yourself confronting the same questions over and over again. And now the question about publicness is not the political question or the parent question of publicness. This is the legal question of publicness. And in Arizona, it turns out that they are sort of an outlier in the ways in which they are the Wild West. They do things a little bit differently out there. And some of those quirky ways are being challenged in court because they do tend to make those charter schools appear as if they have, along the spectrum of quasi-publicness, they might live closer to the private side than other similarly situated charter schools in other places. All to say, litigating these things is not an easy thing to do. Not only do you have costs in terms of getting attorneys and resources, data, school finance experts, kind of the basic things that go into any school finance suit. Charter schools are doing this without any kind of deep pockets. They don't have a school district legal team. They often just try to work with small law firms to the extent they can get them to do it. They work with pro bono firms. And even still, what these folks are trying to do is just to get parity in funding. So what you see more often than not are compliance suits where you say, because it's a statutory discussion, this statute says I should get 90% of what the traditional schools get. I'm getting 50%. There's a clear statutory violation there, fix it. The problem with that is you have to be able to disaggregate what you're collecting and demonstrate how it's only 50% of what you're supposed to be getting. And that seems like that should be easy. I was startled at how difficult it actually turns out to be. So that's sort of the other third big piece of the work that we face. And there's questions about how do you increase funding all around. And what we see a lot of is tying legislative and litigative efforts, right? So if you've got a state house that is interested in the idea, but you can't quite get the political will to get it all the way through, you can strategically file lawsuits so that suddenly you have a little bit more political will to get it done. But there seems to be a lot of the mechanics are difficult. Again, like finding the plaintiffs, finding counsel, finding resources. Filing a suit is substantially harder for a charter school or a charter sector in any state than I would venture to say it is for a district. I'm not saying it's easy for a district, but take whatever stops a district from doing it and basically multiply that by 100. And I think that's what makes it hard for a charter school to do it. Questions? Yes?
One of the issues for people who are not that enthusiastic about charter schools is what happens to the public school, particularly in a third or fourth district, when all the better students go to the charter school. Have there been any legal challenges from groups who are left in those schools? And if so, what are the legal issues or approaches?
It's a good question. There hasn't been any kind of a challenge to my knowledge. Well, I think it comes back to the school of choice. I mean, so take New Orleans, for example. I think the only legal claim you could have there, so a parent of a student who is in a traditional school wouldn't really be able to challenge the state because all the parents chose to go to the charter school. But structurally, I think there could be a claim, and you did see advocates try to argue this, that the state, by creating the Recovery School District, by statute, creating constitutional amendment, doing all this stuff, basically condoned like a two-tier system of education. It doesn't hold any water really in terms of the way that results play out, the way that parents are actually choosing schools. They don't actually have the evidence, but they were trying to make the claim.
It's a hard argument to make.
It's a hard argument to make. From my experience, some of the inequity that is created through the choice mechanism can be leveled by doing certain things like common applications that don't allow each of you in the room operating your own school to offer a different application at a different time whenever's most convenient to you. It's like in New Orleans, I grew up in New Orleans, and when I was growing up there, everyone enrolled for school in August for September. There's none of this like picking your school, like you went to the school down the street, this is just how it works. And I think that's the way it works in lots of places. So when we get down there and we're trying to fix this stuff, or change this stuff, it took years of getting folks to understand, and it's not just like getting parents, it's getting all the businesses that sell uniforms. It's about getting textbooks. It's about all sorts of supply chains that need to be jiggered so that people could start to order things earlier. It's about figuring out when you hire teachers. It's about all sorts of operational issues that come into play, and getting everyone to understand that we needed to be doing this in April. And in order to have parents across the city choose to go to a school in April, you actually have to start doing open houses in January. Lotteries are held in March. Decisions from parents come in April. And that actually lends a whole lot more stability. But like getting parents and communities and families and teachers and school leaders to think about open houses in January versus August is a very heavy lift. But I think when we started to do that, you started to see less of like the less involved parents left behind, because the whole system is catered to making sure everyone knows that you choose on this day. You have this window to shop around. The lotteries work like this. There's one application. New Orleans and a few other places are moving to a centralized enrollment system. So I, as a parent, get to choose 10 schools, and I put that to the district, or some central entity. Doesn't have to be a district. And the entity runs an algorithm and spits out my school. I think there are pros and cons to it, but it does, I think, try to combat this sense that certain parents and families are left behind. Everyone chooses. You do have to do the work of picking which schools you want, but you have to do that in any case. And then you are, according to the algorithm, you're typically given, like 99% of the time you're given one of your top three. So it's not like, only certain people get their first choices and most people get their
That
fifth.
makes sense, but what you're saying is there aren't really any incentives
Right.
or leverages to make that kind of thing happen.
The special education piece has been interesting because I think that type of enrollment system does come as a type of remedy when special education lawsuits are filed. Because, when you say that every parent has the exact same role to play, which is you rank your schools, you submit that ranking, and then given a school to go to, at no point is there even the interaction of me coming to your school, my student is autistic, you clearly see that, and there's, oh, your application got lost. I mean, there's none of that. There's no human interaction. School leaders will say you really lose something. There's a culture moment that's lost there, and there's something real to that. So we've been, in New Orleans in particular, worked a lot with school leaders to help them think about other ways to build culture. I mean, there's a give and take there, but you do start to see certain types of solutions coming about organically. I mean, not even because the courts are saying you should do this, but school leaders are sort of saying, there's a real benefit to school leaders to do stuff like that. You do lose culture moments. Parents do lose some of what feels like more control. I was sitting with friends of mine in DC this past weekend where they got their lottery results, and it was very interesting to watch because they got a lot of different results, and then they spent the rest of the weekend, do I want to go here, go there, and they were, talking about it. I thought to myself, oh, that's so interesting. If we went to some centralized lottery system, they'd get one result. There wouldn't be that dynamic discussion. Is that better? Is that worse? I don't know, but I had not sat with parents before who were engaged in the process of, do I want my kid to go here? What does that mean? Or do I want that school, or do I want that school? And they're, in New Orleans, that's what it's been like. Just this next school year, you're going to move to you get one assignment, and pros and cons, yeah. Either.
I
Duke
have
it
a
out.
specific question.
Yeah.
When the new charter schools here in Loyola are single sex,
Uh-huh.
what is the challenge?
I think it's a good question. So Title IX does permit that type of arrangement. Most authorizers will require some sort of Title IX guarantee, meaning that there's a curriculum requirement, or like you're getting additional educational value by creating a single gender school. I don't think many of the single gender schools have been challenged. I think there is like a parent of a girl who wants to get into that school says, you aren't giving me an appropriate alternative. You haven't seen a lot of that. This is where I wish we weren't being videotaped, but that would be really sketchy. So I have been told that there is an interesting tension, that the Title IX, so the USDOE's Title IX regs for charter schools, so a very narrow piece that talks about Title IX and charter schools, basically says you can create a single gender school as long as there is an equivalent educational alternative provided by the LEA. The phrase the LEA is very suspect, right? Because that could mean me as a charter operator has to run an all-boys school until a girl comes by, and then I have to create an equivalent all-girls school, which that'd be a heavy lift to satisfy that burden. And the question is whether or not if there is an equivalent program in the district. So if I'm in Baltimore and I run a single gender school for boys, is there a similarly good school for girls? Even though I don't run it, can't you just go there? And,
So one kind of justifies the other?
I think it's an interesting question about whether or not, and there's like case Supreme Court precedent that sort of says, I don't think you can say you have to go over there. I think you have to do it. But, yeah.
I don't know if it's a solution, but I've done some work the other day in a charter school in South Carolina that has single-sex classes,
Yeah.
but
Yep.
both genders are in the same school.
Actually, you start to see more and more of that. That people are saying there's a Title IX. Yeah.
Yeah, okay.
So that must make the lottery process pretty fascinating.
You do start to see. I had, some folks in Minnesota do. I've just had random people sort of explain that that's how they get around. Like, they want to provide the benefits of single gender education, but they can't figure out the Title IX part, so they just say boys here, girls here. I don't know. Did you have a question?
Well, I had a comment and a question. The comment was around the issue. Baltimore has also just sent out the results of their lottery, and it is the algorithm that spits out your choice. And I, with a colleague, we're doing some interviewing of guidance counselors and parents, and there is, for all the advantages that it has, there's palpable sense of disappointment on some level, because it's even that, it gets described as a carefully developed computer algorithm, however they describe it, but then you get this choice, and if it's not your top 1, 2, 3, you can really, it's interesting to watch how people react to it, because it's very different than the engagement you described. And I suppose you can have that the same way if those families had not gotten into any of their lots of projections. But I was a little bit surprised at some of the reactions I've seen. So that's the comment. The question is, I really appreciate the way that you've separated out these issues, but how do they come together and how does the law account for that?
That's a great question.
The example that I would give is when you were talking about special education and not focusing on outcomes. And there's all kinds of reasons different schools might have, say a smaller number of special education students or similarly different racial variation than the district as a whole. What does that mean for what equitable funding is? If you imagine, say a district like New Orleans, where it's such a high percentage of the schools are charters, if that means that everybody left in the traditional public system is special ed or something, how do you deal with equitable funding?
Right.
How does
Right.
the law address these kinds of issues?
It's a great question. Luckily, New Orleans is one of those places where there's actually no disparity in funding. Turns out money does follow a kid, and it doesn't matter what school you go to, you get exactly the same amount if you're per district. Varies across districts, but not within districts. So that part is helpful. You nailed it. I mean, I think there's another type of litigation out there to challenge special education funding and the way in which charters are or are not able to access equitable dollars. We've had people want to pursue that. Again, very difficult to disaggregate what you're actually getting and what you're supposed to get. And part of it sounds, almost hard to believe, but these are school leaders. They have a million things to do. They've got COOs, CFOs. They're really not thinking about data, how to collect it, how to disaggregate it. They don't have people on their teams. They're very slim teams who want to interface with their state State Department of Ed. They want more money, but their eyes glaze over in about 5 minutes when you start talking about what it will take to actually mount a legal challenge. You were entitled to more special ed funding. What do you get? I don't know. Okay. Well,
But I was actually thinking about the other way around.
Yeah.
I'm curious when, say, in a district like Baltimore City,
Yeah.
they're going to change the funding formula and dare the charters to sue them again, based on we have a higher and higher concentration of difficult to serve, so equity demands that we actually
Keep
only
more.
give you 50 cents on the dollar, whatever,
Yep.
and actually come outright to say that. Is there any way that people have talked about it from that perspective?
Not yet, but I look forward to figuring that out. I know that they did a pretty good job here in pushing for more equitable funding.
Yeah.
And so you've got some good attorneys that I've had a chance to speak with. I would love to hear their thoughts. I honestly don't know yet. Good to know we can tap on you for some help if we need it.
I don't know.
Yeah, okay. Any other questions?
Could I
Yes.
ask sort of a larger philosophical
Yeah.
question? It seems to me, and I don't think about legal issues very much, so
Lucky
this
you.
may be a very naive question, but it seems to me that the entire system of American education, public education, has until this point, up until the choice movement and so forth, has been based legally on the fact that people basically don't have choices about where they send their kids to school, either by default or by legislation.
Mm-hmm.
And now we have this
Yeah.
radical new idea that the legal system is struggling to catch up with it.
Yeah.
And that these two systems of thought
Yep.
are really antagonistic and maybe will never merge entirely in a peaceful way.
And I think that I didn't mean to interrupt you.
No, that's
Yeah.
basic. I'm not sure I'm
Well-
trying to articulate it for myself as much as I do.
I think that the second and third issues we talked about, the civil rights piece and the fiscal equity piece, a lot of those solutions will likely come through state houses. Ultimately, your courthouses will get you so far. I do really think that most of the sector is driven by people that want to serve all kids. And when I've had to talk to charter school leaders and talk about, well, your numbers look a little low here, what are you doing? I'm not saying you're doing anything wrong, but what is going on? As soon as you explain to them some of their legal obligations, there's a real willingness to adapt. Again, that's my experience. I would say that's generally most people in the sector. I'm not speaking for everybody. I'm sure there are some outliers. That being the case, I think you will see, especially the civil rights stuff, eventually merge, where charter schools are going to be willing to, and I think that the stuff I was explaining about DOJ and OCR and the deseg orders is an interesting example, because as soon as you have that oversight and you have the charter leaders being asked, well, what are your community outreach programs? Like, what are you doing? And, it sort of structures their thinking a little bit about what they can do. They go about doing it, and they actually are fantastic about getting it done. And so I think they're, in fact, one of the schools in South Carolina was overseen by OCR. And, I wouldn't say it was antagonistic. I wasn't there, but there's obviously some sort of authority compliance relationship. And by the end of it, the OCR is basically spotlighting that school as the poster child of what deseg could look like, right? I think that you could see similar types of success stories across the special education front, English as a second language, or English language learners. That's not part of this conversation, but clearly a major part of our education system. So I think in civil rights, you might start to see just like a blending. In fiscal equity, I don't think the courts have ever done a great job of actually assisting. I think there's a lot of carrot-stick issues that go back and forth between state houses and courthouses. But even when you get a courthouse victory, right, in New York State, New York City, billions of dollars are owed. That's great on paper until the money shows up. It doesn't mean that much. And so I think you'll find a similar kind of dance in the charter sector. But I think your point is very, very well taken when applied to the first conversation that we had about the publicness and public entities and public schools. That's really going to be an issue where litigation begins to clarify or further murky the waters. The way that we've kind of approached this is like legislation comes first, right? You've got to get the laws passed. That takes a long time. Then there's a real implementation phase. And then the last phase is litigation. And I think, we've got a lot of legislation in play. Implementation is in the works, right? It pushes back towards legislation. You get improved legislation. And ultimately, it culminates in litigation, and litigation goes back to the legislation and drives it forward again. And I think in the public entity sphere, that's where a lot of the lawsuits are. What does this stuff mean? And unfortunately, because courts are operating not in connection to each other, right, for the most part, you have a lot of wildly conflicting decisions, right? So it's very fact-specific, it's very circumstance-specific. So in this case, with these facts, in this jurisdiction, in this state statute, it looks like this, which really doesn't mean that much to someone else across the country. Unfortunately, so many of the legal questions are questions of first impression. There's no case law on it. Courts are strapped for time. They're looking for efficiencies. And if there's some other court somewhere that's thought about it, when I was clerking, it was like, go find the case, figure out what they were thinking about, and see if it applies. And the problem is the clerks in the courts, they're not education experts. They're not charter school experts. And, they're making decisions in a vacuum. So in terms of like creating clarity and cohesiveness, I don't think the court's the best way to get there. But I do think they will be the ones that tackle the public entity issue. State houses have been dealing with that phrase. That's part of what led to the 164-page treatise on 4 states. That phrase has been in play for hundreds of years. It just means wildly different things. So that's not a very reassuring answer, but, Any other questions, concerns, thoughts?
South Carolina, I work in South Carolina, I'm here visiting.
Oh, cool.
Can you, I know you can't identify the school.
Not on camera.
The area of the state?
Nope.
Okay.
Not a chance.
I can tell I've talked to a lot of
Privilege being privileged, yes.
Maryland has a weak law, and it's probably not going to
Yeah.
change very much in the near future, at least till after the election. How does it compare to other states?
That's a great question. Todd will actually come here in a few weeks and will not only show you the model law, but then our organization puts out a rankings report. So it compares every state's law, and it's revisited annually because there's so much change with each legislative session. That's also my way of punting, because I should know that answer. I think it's lower on the list.
I'm going to say 36.
Yeah, I was going to say 38.
40.
Yeah, 2, yeah. So it's definitely in the lower
Is it
quadrant.
actually in some state constitutions? You mentioned state constitutions.
there's case law that, it's not, charter schools per se are not, but then there's case law that understands charter schools to be part of the system of public education. Because that was like the first wave, you know, was, these aren't public schools, look, it's not in the Constitution. And then the courts were like, it's in the state statute, it's recognized as public school in the state statute, the legislature gets to design the system of public schools, so nice try. But for every step forward that we take kind of with the courts in that respect, we get bad decisions too. There was a court case out of Georgia last summer, state Supreme Court case, that basically surprised everybody because it went left when we were pretty sure they were going to go right. And they revisited what was established language in the Constitution, in the state education clause, and didn't find that charter schools were not public schools, but rather found that the growth of charter schools couldn't be directed under the state's jurisdiction. It had to be a local issue only. No, I mean, this was a question about whether or not a state board could authorize, and the court said, can't, it's a local issue. It's a local control issue, and it's only local districts, which is, you know, unfortunate in terms of a policy point of view. I mean, legal point of view, I think their decision was kind of comical, really. I mean, it was just strange. But at the same time, from a political point of view, it's also worrisome because many local districts don't want to authorize charter schools because it's like breeding competition, and you know, there's some hesitancy. It's nice that the Obama administration has sort of cajoled states and districts into doing some of this stuff, but that doesn't always mean that it goes well, or like that there's harmony there. Yeah.
A lot of the examples that we've talked about today, both in terms of your three areas and questions, pit charters against traditional public schools. But sometimes that I wonder if there's not a divide and conquer thing going on where that, you know, it can cause each group to be diluted in their request for better funding on the whole for education and these kinds of things. Do you have any interesting examples of charters and traditional public schools actually working together on legal issues?
Mm-hmm. Actually, I do. Well, now, I mean, you probably all know about the district charter compacts that are going on around all these cities. And it's not legal, but it is policy, that you start to see a lot of policies that bolster the position of education generally, whether it's around enrollment issues, funding issues, labor issues, union issues sometimes. So you start to see some of that. In a fiscal equity suit, actually, you do see districts often filing and charters moving to intervene or to join. Like, the charters often wouldn't have the capacity to launch suit all by themselves, and they wouldn't necessarily get as much bang for their buck. But once districts start filing against the state, charters are right there too. And I think that's an interesting opportunity for collaboration. Sometimes it's not seen that way, because if you define the pie as only this big, then it's everyone fighting for more of it. But I mean, to your point, ultimately, you could probably expand the pie. And I think the courts tend to sometimes push legislators to expand the pie ultimately. But I do think and they often will bring different allies, political allies to the table when you have litigation that involves both districts and charters, which can also make for some interesting political movement. Yeah.
Any other questions? Renita, thank you.
Thank you. This was fun. I had a good time. Thank you.
Thank you all for coming.